Well, an issue that can arise in agriculture is the government's ability to surveil the farm without a warrant. While the Fourth Amendment protects against illegal search and seizure of a person's home, what about private land not located in the surrounding vicinity of the home? Well, Roger McEowen with the Washburn School of Law joins us now with a bit of insight on the situation. Roger, as always, thanks for your time here today. So what are some of the general elements to keep in mind when it comes to curtilage and agriculture?
Well, the key term here, Janet, and good to be with you today, is curtilage, and that's generally defined as the land that immediately surrounds the individual's home or their dwelling place. And that includes, in the farming context, any closely associated buildings and structures. But it does not include, and this is the key point, it does not include open fields or buildings and structures that contain separate activities conducted by others or the family that's not associated with the home. And the extent of that is really with reference to its association with the home. And there are a number of factors courts look at in determining whether we're dealing with open fields or whether we're dealing with the home. And so we look to the nature and the use of what that other area is put, the steps taken by the resident to try to protect it from observations by passersby, and so forth and so on.
So a great deal of farming and ranching activities, of course, does occur out in the open. How can government officials go about making warrantless searches of such areas?
Well, they can trespass, they can set up cameras, for example, they can take pictures. They can do just about whatever they want to gather information on you without getting a warrant backed up by probable cause. The only limitation is for, again, the areas that are closely associated with the home.
Now, do these rules vary by state?
Well, that's a good question. It is possible that a state constitution might have greater restrictions on the government's ability to conduct a warrantless search, but many don't.
Do you have any examples, Roger?
Well, I think one of the most egregious examples was a Tennessee case in 2019. And in that case, state and federal wildlife officials trespassed onto a farm by crossing two fences to get to the interior part of the farm. The land was posted as no trespassing, and this is why this case is really upsetting to a lot of people. The landowner had posted it as no trespassing, but the wildlife officials zip-tied cameras to trees, and the landowner finds the cameras, and then later the government raids his home with their guns drawn to get their cameras back, and the court said, no problem. The cameras were in an area not associated with the home, so they didn't need a warrant.
Is that case still ongoing, or has it already been decided?
Now, that one's been decided. There are some other cases across the country that are ongoing, and this is a huge issue that's out there. And so farmers and ranchers need to be aware of this, if there's suspected environmental issues, say baiting of birds if we're hunting migratory waterfowl, those types of things. That can be an issue, and the government doesn't need to go get a warrant backed by probable cause from a judge before they can come onto your property and gather evidence.
So, Roger, what would you say is the big takeaway for farmers and ranchers?
Well, if you think you're free from a warrantless search on your farm, you aren't. And that's, I think, the big message, unfortunate message that we have to deliver.
Do you anticipate any of the cases similar to the one that you described for us could actually maybe go to a higher court sometime?
Well, there are two really prominent Supreme Court cases on this, 1924 and 1984. And 24 is when they came up with this open fields doctrine, and then they bolstered it in 1984. But in the 84 decision, there was a very biting dissent. And that dissent is very strong. It's still there. It is a dissenting opinion. Obviously, there weren't enough justices to throw that one into the majority. But I would think, given the current makeup of the court and the emphasis with them in protecting private property rights and upholding the Fourth Amendment's provision against warrantless searches, that if a case like the Tennessee case with an egregious set of facts got to the court, they may pick away at their precedent that was established in 24 and again in 84. So we shall see.
All right. Well, Roger, as always, thank you very much for your insight this morning. Roger McEowen, he's with the Washburn School of Law, connecting with us. You can go online to washburnlaw.edu/WALTR for more information. Again, Roger, thank you.